Hello and welcome to Section 6 of our Title IX training series. My name is Dean Shatley at the law firm Campbell Shatley. I'm here with my colleagues Chris Cottle and Ashley Leonard. Again, this is Section 6 on investigations. Chris, if you could flip the slide. So you see the preview list there of the slides. I'm going to go ahead and Chris is going to take the lead on this one, so I'll go ahead and turn it over to him.
Thank you, Dean. Looking at this preview slide, kind of seeing some of you may have been with us for all these trainings. Others of you who are focused in on just the investigation part of this may just be jumping in at this point. But you can see where we started, sort of going broadly there with Title IX fundamentals, looking over model policies, figuring out the definitions and the interplay for Title IX personnel, compliance matters, how to respond to allegations, particularly for the Title IX coordinator. This training is going to focus specifically on the part of the process where a formal complaint has been filed and the school district is conducting a Title IX investigation based on that formal complaint. So we're going to go through the moving parts of how to conduct a proper investigation under Title IX, and let's just kind of jump right in at some of the big picture topics. Again, this sort of flow chart that we've been using kind of leads you to where we're at here. We're sort of in the third phase of the Title IX process. This assumes that, a Title IX incident happened, it's been reported, the school district has actual knowledge of it, Title IX coordinator has done an initial assessment and has determined that it does fit within the definition of sexual harassment, and it happened within an education program and activity, and the complainant has filed a formal complaint, or the school district is proceeding based on the complaint that was alleged, and now a investigation has been triggered. So the investigation part, as you can see here, step 3 in the process, comes before any decision or a hearing if your district is going to provide for a hearing, and before any appeal. So the investigative phase is really the critical piece for the decision makers to base some of their decisions based on all the evidence that was collected. So let's talk more about what your obligations are, your roles are as an investigator. We'll kind of start out by looking at some of the general equitable principles that Title IX tries to effectuate through the Title IX rule as it comes to investigations. We'll look at, again, when to investigate, at what point in the process does it make sense to go ahead and order a formal investigation, who the investigator is going to be, the components of that investigation. One thing we'll spend a decent amount of time on is talking about how the requirements of Title IX and the investigative process for Title IX intersect potentially with ongoing criminal investigations, and how to balance those competing interests for the school district. We'll also look at the notice of allegations, that what has to go in that notice, who it has to go to, and what has to be in it. Again, the nuts and bolts of conducting a proper investigation. We're also going to look briefly at this notion of an advisor, who is someone that it is a role that you may have some contact with in the investigative process. We'll talk more about that. And then finally, in putting your investigative report together, collecting, analyzing, and weighing evidence appropriately to go in that investigative report. So that's a lot of topics, but we're going to look at them one by one in this training. These equitable principles I touched on briefly. As the investigator, remember, your job is to investigate all the facts and look at them impartially, look at them objectively, and determine based on the evidence whether or not the allegations amount to a policy violation, the Title IX policy violation that the school district has into effect. So keep these sort of principles in mind. Some of them will come up in different areas of this training, but this is sort of the bedrock of due process that is inherent in your investigative function. So just keep them in mind at all times. You can look at each one of them. I mean, I think one that kind of stands out to you and this is a component that will go into the notice of allegations, is that the respondent is presumed not responsible for the alleged conduct. That's something we'll talk more about in what goes in the notice of allegations, but that is sort of the presumption that you start with as the investigator. We'll talk about burdens of proof, what the standard of evidence is, and what you're collecting. The opportunity to analyze and participate in the investigation of the parties at equal right. We'll talk about that. Giving notice of any meetings and interviews and the proceedings. We'll talk about those things. So from a holistic standpoint, just keep these principles in mind as we go through each component of this training, because it's kind of just embedded in your role as an investigator.
Chris, I want to jump in on that last slide and just point out again that these equitable principles you were talking about really come down to a couple of different premises. One is that the investigator remains objective throughout the process, that the investigator is not biased or does not have any type of conflict with any of the parties and hasn't made up his or her mind prior to starting the investigation and really prior to even finishing the investigation. So that is the primary premise here, is that they have to treat both parties equally, treat the respondent as they are not guilty yet, or responsible, treat them as that we have the burden of establishing whether or not they are responsible, not that we already have determined that they are responsible. So keep those in mind at the beginning of any investigation, because you have to kind of get in the right headspace, especially if the investigator is a school administrator who might be used to working pretty quickly, getting through these things pretty quickly and making a gut call on what he or she believes happened or who's at fault. And here, for a sexual harassment investigation or sexual misconduct investigation, the investigator is really going to have to take a step back and really attempt to look at this through an objective, neutral lens.
So let's look at just some terminology that you'll see in the policy, and you'll also see embedded in your function as the investigator. So as far as standards of evidence go, there are really three that are commonly used in a court of law. And the one that is going to be most applicable to you and as well as the decision maker in the Title IX process is the preponderance of evidence standard. So that is the standard that's used. It's a civil standard in court. To meet that standard, you have to have evidence that proves that a fact or event was more likely than not to have occurred. So that's somewhere above sort of 51% or 50% plus one. That is evaluating all the evidence you believe the allegations were more likely than not to have occurred. Now, that is important because that is the general sort of standard that is probably going to be used in your policy. Compare that to other higher standards of evidence which are used in different contexts, like the clear and convincing standard and the beyond a reasonable doubt standard. The clear and convincing standard is somewhat higher than the preponderance, and you can see from the definition there, to meet the clear and convincing standard, you need proof that a particular fact or event was highly and substantially more likely than not to have occurred. So that just means that in order to meet that standard, you need more evidence and more proof to support the allegation to meet that standard. So again, you're going to most likely be using the preponderance standard, but compare that with the clear and convincing, and then also the beyond a reasonable doubt standard. That is the highest standard of evidence that is used, and that's used solely in the criminal law context, where a person who is accused of a crime is presumed innocent until proven guilty beyond a reasonable doubt by a jury of peers. And beyond a reasonable doubt is a very high standard. Typically, the evidence has to be so compelling that there only one conclusion could be reached. So you won't be using the beyond a reasonable doubt standard in conducting your investigation, but you should keep in mind the principles for preponderance and clear and convincing as you are conducting your evidence, and likely you'll be applying the preponderance of evidence in making a recommendation on the evidence in your investigative report. So let's look at the big picture here, the elements of an investigation. So again, the purpose of this whole process is, the investigative process is a fact-finding endeavor to determine whether or not the respondent violated the school district's policies under Title IX. And importantly, if there was a policy violation, what steps is the district going to take to end that harassment or violence and eliminate the hostile environment and prevent its recurrence? Now, the common thread to everything we're going to talk about in terms of your investigation and the real standard for an investigation under Title IX is that an investigation needs to be prompt, thorough, and equitable. And so that kind of goes back to what we've already talked about with these general equitable principles. So in the back of your mind, when you're wondering what is the standard for my investigation under Title IX, are the things that I'm doing, are they timely, are they appropriate? Keep prompt, thorough, and equitable in your mind. Prompt means that we are conducting an investigation in a pretty timely manner. The policy, as we'll look, sets forth some timelines for the start and the completion of the investigation, and we'll talk about that in later slides. But the idea being that once we receive an indication that we need to investigate, that it's being handled pretty promptly and it's not being delayed unnecessarily. The idea that the investigation is being thorough, so that means that you are interviewing all relevant witnesses, and we'll talk about how to conduct those witnesses. You're analyzing all relevant evidence, and that you are in the process of doing that, being equitable and treating both sides, both the complainant and the respondent, equally as you are following each step of the investigative process. So prompt, thorough, and equitable, that's the standard you should keep in the back of your mind throughout this entire process. Just some high points there of things that the investigation will typically include. It varies a little bit depending on whether you're investigating a student on student issue or an employee on employee issue. So you can expect that in both, you're going to conduct interviews with the parties and the witnesses that they identify. To the extent that there's law enforcement involved or a parallel law enforcement investigation, reviewing some of those documents, reviewing student or personnel files that are provided may be paramount to determining whether or not the allegations meet the standard of evidence. And then also your function in sort of conducting the investigation, gathering and examining all those documents, summarizing them, and putting them in a Title IX investigative report that'll be used in the later decision-making process.
Chris, I want to jump in here and talk very specifically about these interviews. Now, many times in the Title IX process, it's either going to be somebody in HR or a school administrator being the investigator. That's kind of how it is set forth in the School Board Association policy. And the investigation isn't necessarily anything different than how you've investigated before, but it is more formalizing it to include, we want to, kind of package it all together. We want to have it ready to send to the decision maker who's going to make the ultimate decision as well. But it's really not going to be much different than what you've done in the past, other than we're going to add some formality to it. Now, when you are conducting your interviews with the parties and the witnesses, always remember that just because you've interviewed a witness or one of the parties once doesn't mean you can't go back and interview them again. And most likely, you will need to go back and interview them again. You may need to interview parties multiple times. One party says, this happened, the other party denies it and gives an alternate explanation. And so you want to go back and ask the first party about the alternate explanation to see what you can corroborate elsewhere. And so keep that in mind, that just because you interview somebody one time doesn't mean you can't interview them again. And most likely you will need to, especially in complicated cases where there's not a lot of corroborating eyewitness testimony or video or audio recording that demonstrates the conduct as well.
All right, so let's just kind of start with when to investigate and who is going to conduct the investigation. So we know when to investigate. The Title IX coordinator will have made a determination that the conduct falls within Title IX, the definition of sexual harassment. The complainant will have signed a formal complaint, or the school district will have taken on a formal complaint on its own. So who is going to conduct that investigation? Look first to the model policy. If the respondent is a student, the investigator is the principal. Now, there is a little flexibility in that for the principal. It could be the principal or another designee of the school district. If the respondent is an applicant or an employee of the school district, then the investigator is the senior human resources official or designee. So we talked in previous trainings about one of the reasons that we have a little flexibility in that policy is to avoid potential conflicts of interest and potential bias, or at least inferences of such in the process. That may be an issue that will be an issue that the Title IX coordinator will need to consider in appointing an appropriate investigator who's trained in each individual circumstance. So that's one of the things we've listed here as well. Conflicts of interest are something the Title IX coordinator has to determine. They need a neutral investigator who's trained. Sort of as a general matter, under the policy, that person in the student environment should be the principal, and in the HR environment, it will be the senior human resources official. But there may be circumstances where those people cannot serve as the investigator because of prior knowledge of the student, or either students related, or prior discipline related to that incident or similar incidents with that student. So it's going to vary on a case-by-case basis. So Ashley and Dean, again, just to kind of reiterate what we said in previous trainings, what should the Title IX coordinator do when they get to this point in following the policy? In really, what can they do if they don't feel like the principal or the HR person can serve as the investigator?
Go ahead, Ashley.
I think if they don't feel like the person who's appointed in the policy to investigate can be the investigator, either for a conflict of interest, or the person has shown some implicit bias or predetermined outcome, they can assign someone else to investigate. So let's say it's a student-on-student complaint. So generally your investigator is the principal of the school where the conduct allegedly occurred. And that principal has made some comments to your Title IX coordinator that indicates that they would have a predetermined outcome of the investigation. Your Title IX coordinator should assign either a different principal from a different school as the investigator, maybe an assistant principal, but your Title IX coordinator has discretion to assign the best person for the neutral position that the investigator needs to be.
All right, so again, we're going to talk in a number of different ways about parallel criminal investigations. So kind of leading into that topic, remember that we're conducting an investigation under Title IX, but your investigation under Title IX does not impact the reasons that are set forth in state law that principals might need to immediately report to law enforcement certain acts that occur on school grounds. So we've got them kind of just listed out here. You're probably familiar with these and the reporting that takes place. But if you look at the definition of sexual harassment, remember that is particularly very broad. Sexual assault, by its very definition, would be considered sexual harassment under Title IX. So certainly some of these instances of conduct that are going to amount to criminal conduct would also fall within the purview of sexual harassment. So the Title IX investigation and Title IX requirements are really not intended and do not affect your state law requirements to report to law enforcement these particular acts that happen on school grounds. And we'll talk about in a second how the presence of one of these issues and an ongoing law enforcement investigation could impact your Title IX investigation. Dean and Ashley, do y'all have any other thoughts on the reporting function here for a principal who might also be, called upon to be an investigator?
Absolutely. And this, 115C 288G has been in the law for a long time. There's been a couple of different iterations regarding what the principal has to report or when they have to report it and who they have to report it to. But, what it boils down to is if the principal has a good faith belief, there's a good faith allegation that there's been some sort of a sexual assault offense, indecent liberties, or anything else listed on this slide right here, they have a legal duty to report it to law enforcement and to the superintendent. And so technically you should just, if it involves sexual harassment or sexual assault or sexual misconduct, you should just include in your list of people to report it to include the Title IX coordinator as well. You have a federal legal duty really to send that to the Title IX coordinator. But these are two parallel reports. One doesn't change the other and one doesn't trump the other. There's nothing in conflict here. And so if you get some sort of information, good faith information about a sexual assault, you need to report that to law enforcement, your superintendent, and Title IX coordinator immediately as soon as possible. So just keep that in mind and make sure that you don't forget about this very important statute.
So let's talk about, again, the intersection with criminal investigation. There is no requirement under Title IX. The slide we just talked about really hits the point home. Title IX doesn't require that a school district report alleged criminal incidents to law enforcement, but North Carolina state law does. So try not to confuse those two while you're conducting an investigation. For the Title IX coordinator, in the interactive process of acting and responding to the initial report, it's very important that the Title IX coordinator, does not dissuade the complainant from filing a criminal report. I mean, that's certainly their, along with their parent, their prerogative, their option about whether they want to do that. The school district shouldn't do anything to dissuade them from doing that if it's not one of the incidences that is a mandatory reporting situation for the school district. So that we talked about that in a previous training, and that's something that you should be doing in that initial interactive process, and also documenting that you inform the complainant that they had options to go to and file a criminal report. Also keep in mind that, to the extent that there is an ongoing criminal investigation, the facts and the investigation at the criminal level may be very good evidence and very helpful for you as the investigator in completing your investigative report. So certainly that is something that, you should keep in mind, and we'll talk about ways to do this in a second, but you should be trying to get as much information as you can from law enforcement in order to inform the Title IX investigation as well. So there are some moving parts to that. So let's look at those. But one thing you can't do as a Title IX investigator is just sort of categorically wait for a criminal investigation that's also happening to be completed before you do anything under Title IX. So although there is some overlap in the investigating and the fact finding, the Title IX investigation is a school district requirement, and it should proceed along the timeline set forth. Remember, prompt, thorough, and equitable. It should proceed along that same timeline regardless of what is going on in the law enforcement space. So you have to walk this tightrope where we can't categorically wait for the end of a criminal investigation. But for obvious reasons, the criminal investigation may be very relevant to our investigation under Title IX. So there may be a need to temporarily delay an investigation for a short period of time while law enforcement and criminal investigation is ongoing. So important in kind of walking that tightrope there is, documenting to the extent we need to delay for a particular reason, documenting that need and informing the parties and keeping them updated on the status of your Title IX investigation and the timeliness. Also very important, in other trainings, we've talked more about supportive measures and how those can and should be offered in the interactive process by the Title IX coordinator on the front end before an investigation. Keep in mind always those supportive measures should be offered and continued throughout the course of an investigation, and any delays that might happen due to a parallel law enforcement investigation should be continued in place throughout the investigation.
And Chris, there's the possibility of some real tension here, especially if the alleged conduct is relatively egregious. So you want to check with law enforcement. You want to make sure that we're not stepping on their toes. But on the other hand, we have to make sure law enforcement understands while we can delay some to allow them, for instance, to interview witnesses first, to interview the claimant first or the respondent first, and certainly in their eyes, it would be the victim and potential defendant or person of interest. But we can allow them to do that, but we have to make sure that law enforcement also understands that we have our own duty under federal law to engage as promptly as possible in our investigation too. And of course, what Chris talked about, those supportive measures being in place during the delay, that can include, no contact order, can include potentially the emergency removal of the respondent from the school environment or into another school environment as well. So keep all that in mind, because I could very well see, if a complainant comes forward, makes a report of sexual assault, the principal automatically calls law enforcement. Law enforcement says, don't do a thing. We want to interview the respondent. We want to surprise the respondent. So don't tell the respondent about the allegations yet. So we want to surprise the respondent and see, to gauge his level of, whether he denies it or she denies it. And so a lot of times law enforcement will do that. So we need to ensure that occurs quickly so we can, promptly begin our investigation too.
And I think, Dean, what you're saying is exactly right. And it kind of builds to this idea of having, hopefully collaboration and a good working relationship with your local law enforcement on these type of issues. On the one hand, we want to work with law enforcement and we want to be able to get as much information from them as we can to inform our Title IX investigation. Sort of the other side to that coin is we're very limited in some ways as to what we can provide to law enforcement. So there are FERPA issues there in terms of sharing information directly to law enforcement without a subpoena. One of the best ways to sort of get ahead of that issue, and many of you probably already have done this, is to have an MOU in effect, which talks about the process and the sharing of information and the scope of that regarding concurrent criminal investigations and school level investigations, which would include a Title IX investigation. So if further questions on that, speak to your local board attorneys about whether you have an MOU directly for something like that, or if you need something sample to move forward with it.
Yep. And always remember that there are several exceptions to FERPA, especially in regards to law enforcement, school district sharing information. One of those is if it is an actual emergency situation. And if it is an emergency situation, we can share information about students with law enforcement. And two, a teacher or school employee talking to a law enforcement officer or detective about what he or she saw or witnessed or heard, that's not a FERPA violation either. To just give kind of witness testimony to law enforcement is fine as well. So school employees can do that. Now, if law enforcement wants to see a student record, they're typically going to need to have some sort of legal permission to do so unless it is an exception or fits an emergency or fits one of the other exceptions.
Exactly. All right, so we looked at criminal investigations, their sort of intersection, when investigations start. So this right here is one of, again, about 5 to 10 areas where we've highlighted throughout these trainings where you as a Title IX coordinator, for the benefit of the investigation and just holistically for the process, this is really a form letter that you should work to draft and keep on file to be used and changed based on the facts of every case, to meet this requirement of providing written notice of the allegations which trigger the start of an investigation. So once a formal complaint is filed under the School Boards Association model policy, the Title IX coordinator has 5 business days to provide this written notice of allegations. And you can see in the bullet points here what that written notice of allegations needs to include. These are things that are required under Title IX, and they are intended to promote equitableness between the parties throughout the investigative process. So sufficient details to allow the parties to respond and prepare for the initial interviews that the investigator will conduct. The identity of the parties involved, that's a critical component of this as well. If a formal complaint's been filed, the notice of allegations under Title IX, the respondent is entitled to know who's filing the complaint. So that needs to be included in the notice of allegations. A summary that is sufficient to show what the conduct alleged to be and how it was sexual harassment, date and location of alleged instances, basically the basic things that you would expect to want to know if you were a respondent and someone was making an allegation of sexual harassment against you. We talked about this earlier, but there has to be in the notice of written allegations a statement that the respondent is presumed not responsible and that responsibility determination is made at the conclusion of the Title IX process. And then the parties both need to be on notice that they have a right to an advisor. They have a right to review evidence that's collected, and we'll talk more about both of those in later slides. Also, a notice that the district prohibits making knowingly false statements or submitting false information as part of the Title IX investigation. And also, if to the extent that it hadn't been provided thus far, always include a copy of the district's grievance process, making sure that that's part of what you're sending out. Ashley, we talked about this being in a form letter, but if you're a Title IX investigator, any other best practices for how this should go out to the parties?
If you're an investigator?
Well, if the Title IX coordinator sending out the notice of allegations.
Best practices, I would say send it out simultaneously. You can send these out through email if you're doing it through your school email to their student email addresses. You can mail them, you can hand deliver them. I would say whatever method you choose, you just do it the same for each party and preferably at the same time.
Exactly. And I think just no reason you can't do this electronically. I would say that the substance of what's in the notice of allegation should be probably its own separate document. But if that document you want to email out simultaneously to both parties, just provides a record of the date that it was sent out, because to show that we're in compliance with our policy, and the date that this is sent out is also going to trigger the date that our investigation timeline begins. So making sure you document these timelines and that the substance of this was provided to both parties is critical to ensuring due process. So now we're going to talk more about so the parties have been informed, the notice of allegations, the investigator has been appointed. Always remember, as we've said before, the investigation needs to be prompt, thorough, and equitable. So under the model policy, there is no particular timeline in Title IX for how long an investigation should take. So the model policy sets out 90 business days as being a reasonable amount of time to meet the promptness requirement under Title IX. So the school district under policy aims to bring all the investigations that it undertakes to resolve them within 90 business days from the date the Title IX coordinator determines the investigation should commence. That will be the date that the notice of allegations are provided to the parties. So 90 days is, 90 business days. I mean, that is a decent amount of time, and many, if not all, of your investigations can be concluded pretty easily within that time period. But there are definitely going to be situations where 90 days is just not enough time, and some of them are pretty common sense. So the School Board Association policy does have and provides for reasonable extensions of time, which the investigator can cite as long as they can cite good cause, and we have each one of those in the policy listed below. If you are an investigator and you're finding for a variety of reasons that you just are not going to be able to meet that 90 days, you need to let the parties know. This is another form letter that the district will need to create. Let the parties know why, what the good cause is. You can see just as they're listed here, many of them make sense. In some of these situations, we may have multiple complainants, multiple respondents, which means we've got a lot of people to interview, some on campus, perhaps some off campus. Scheduling those can be problematic depending on the circumstances. There may be numerous allegations, so it may not be one singular allegation that we're investigating. It may be numerous allegations, and it may span over a long period of time. So depending on those factors and the availability of the parties, you can see that the time may start running. Now, other sort of just practical, calendar type stuff. I mean, if we get a report and an investigation starts right before a holiday or right before a long school break, you can see how the expiration of that time is going to extend this amount of time. Now, in the policy, I believe business days, if it's not defined, business days wouldn't include days that school is, well, it may or may not include the days that school is in session. So make sure you're taking that into account if you get an investigation starting right before a long break or a holiday, because that will affect this timeline. Other sort of unforeseen circumstances and good faith reasons, again, maybe there's a parallel criminal investigation that we are working with law enforcement and waiting for them to conduct investigation or conduct interviews. That shouldn't be a reason by itself to delay our investigation, but it may affect our timeline, and if so, would be good cause to extend it beyond the 90 days. And certainly the unforeseen circumstances would include situations like we are in right now with COVID-19, where because school is either in session or some students are attending school only remotely or through a hybrid model, and certainly the changed circumstances with that may be a legitimate reason why you're not able to finish your investigation within those 90 business days.
So one thing to note here, Chris, is that a lot of times an investigator is going to need to finish up the investigation in a period of time way less than 90 days. You're going to need to get it done in 10 days or 15 days. You've removed a student through an emergency removal potentially, and you're looking at the possibility of the student coming back. So you've got to, there's got to be a consideration of some sort of suspension or long-term suspension. And so you're going to want to get this investigation done quickly, especially for less complicated student-on-student allegations. So keep that in mind. And one other question, I don't think you covered this, I didn't hear you say that, but if the investigator needs additional time, needs an extension, who do they go see to get the extension?
Well, I mean, they should probably reach out to the Title IX coordinator, but and cite the reasons for good cause. But the good cause should be reduced to some sort of a writing, whether it be an email or a letter that goes out to both parties, citing the need to extend the investigation beyond the 90 business days. But again, for the Title IX coordinators that are out there watching this, I mean, your job, as we've said throughout, is to coordinate this entire process. And that means, you are not the one conducting the investigation, but you are certainly the one that's facilitating it and keeping up with compliance with the policy and the requirements of Title IX. So definitely should know if the investigator is going to need longer than this to complete their investigation. All right, let's talk also about actually conducting the investigation. So the notice of written allegations is out. You have an idea of who the complainant is, who the respondent is. You actually need to jump in and start the investigation. So typically that would start with an interview with the complainant and then also an interview with the respondent, following up on the allegations that were made in the formal complaint, taking their statement, meeting with them either in person or if not in person, then through some sort of visual medium like a Zoom type of a platform, or just with a telephone call. And also any witnesses. So the conduct that's alleged may be directly just with the complainant and the respondent, but as you meet with the complainant and the respondent, you should ask them whether or not they have any witnesses to the conduct to support their side of the story and rebut the allegations or support the allegations. Those additional witnesses should be followed up with, and it'll vary who those witnesses are. They may be other students in the school district. It could be people who are completely external to the school district at all. So your job is to, again, be thorough, to meet with these individuals and take their statements, ask them questions that you are finding, review the evidence, ask them if they have any documentary evidence that they want to provide as a part of the investigation, and start collecting all that and putting it together in a record that will ultimately be shared with both parties. Now, I'll say this right now, and depending on who the respondent is and what their current situation is at the school and who witnesses may be, what do you do, Ashley and Dean, if you can't get a respondent or any of the witnesses to participate? Do they have to?
No, you can't. Under Title IX, you can't compel anyone to participate in this formal grievance process. That doesn't mean that you can't encourage them, let them know potential outcomes if they choose not to participate. But you also have to be aware that you shouldn't be seen as browbeating someone to participate in the process. Ultimately, it's up to individual choice whether to participate. Let's say a witness or multiple witnesses decide they do not want to be interviewed by the investigator. The investigator needs to move forward, try to collect sufficient evidence to make a determination of whether your Title IX policy has been violated. And if your investigator is coming to your Title IX coordinator and saying, I just am unable to gather sufficient evidence because people don't want to participate in this process, your Title IX coordinator has discretion to determine whether to dismiss a formal complaint for that basis.
Exactly. And so again, along those lines, one of the other things you should make sure you're doing, if you're having trouble getting in touch with any of these parts, the complainant, the respondent, or any witnesses that have been identified, documenting your efforts is helpful and is critical in showing that we conducted a thorough investigation, noting that you tried to call or you tried to email and you didn't get a response, or if the person did respond to you but you haven't been able to set up a time to talk with them. Noting all those things shows your thoroughness in trying to uncover all the facts in the process. So one of the other keys to this is, and we've talked about a party's advisor and other trainings, but generally speaking, an advisor could be anybody that a party wants to help give them guidance or be present at any part of the investigation or the decision-making process. there is a limit and a scope to sort of what the advisor can do, and they really shouldn't be participating in the process, but they do have a right, if a party wants them there, to be present. So keep in mind that as you interview a complainant or respondent, they may identify a person. It could be anybody, could be a parent, could be a neighbor, could be an attorney, really could be anybody that they want to serve as their advisor. They do have a right to be there, and you may have some interaction with those people as well as you're conducting your investigation. Dean, I'll ask you this question too. We've got a note here about recordings. Title IX allows investigators to record interviews with parties. Is that a good idea? Do you think that investigators should be recording their investigations as they are going through the process?
Well, there's pros and cons to recording, Chris, and one of those pros is that the investigator will have the witness interview to go back to and listen to and re-listen to ensure that the investigator has down accurate information when he's completing his report or her report. The con is that these interviews most likely will have to be given to the other side if there is some sort of discovery later on, or even if there is a due process disciplinary hearing, or if you have a hearing, specific live hearing under the Title IX policy, which we'll talk more about that, and we have in other sections as well. So there are some pros and cons. Ashley, what do you think? What interest outweighs the other?
I think you hit it on the head, that it's really, really important to keep in mind that whatever evidence the district collects throughout the investigation must be shared with each party. And that goes for evidence that the district does not intend to rely on when they're writing the investigative report or making a written determination of responsibility. So if your investigator does decide to record interviews, like Dean said, that's the best way to ensure accuracy of interviews when you're writing your investigative report, but you would be required to turn over those recordings to each party at the end of the investigation. And that's something to consider for sure.
So I think just, from the investigator standpoint, just be aware, that as you're conducting this investigation, just be aware that all the records that you are creating will be shared with both parties at the conclusion of the investigation. So your job is initially to do the investigation, collect all the evidence. You're going to summarize that evidence and provide an investigative report, which we'll talk about in later slides. But the records that you are creating and the evidence that you are collecting, both parties will have access to it at the end of the process. And, to the extent that there is, litigation related to it later on, it's all discoverable. So just be careful with what you are creating and understand, have a purpose for what you're doing as you're completing the investigation. But certainly the accuracy, especially if there are multiple allegations and multiple complainants or respondents, and it's a very complicated process where you've interviewed a lot of people, having a recording is probably going to be very helpful for you in going back and completing and creating the investigative report. One final piece on all this is we've got listed here follow-up interviews. I think that interviewing the complainant, interviewing the respondent, and any witnesses, circling back around and doing a second interview with both the complainant and the respondent is a good rule of thumb in each investigation, because you may have learned additional information which either supports or rebuts what you heard from either of the parties in your initial investigations. You may have spoken to other witnesses who provided documents and statements that corroborate one or the other testimony, or directly counteract what a complainant or respondent told you. So going back and following up on those loose ends and trying to streamline those is very important to uncovering the it's very important in the fact-finding process and also in judging the credibility of of the parties and the witnesses as you've interviewed them. Won't spend too much time on this because we just talked about it in the last slide, but again, you may encounter an advisor. A party is entitled to have them. They can be present during the investigative process. Their role is really limited to guiding and supporting the party in the process, not really participating or controlling the process. And that's a fine line there, that as an investigator, you will have to make sure that the advisor is serving an appropriate role if you are interacting with them during the process. So they're expected to refrain from interfering with the investigation. And it's very important to set forth at the very beginning that they are expected to maintain the privacy of any records that are shared during the course of the investigation where they may be present.
But one thing to note here is that the respondent or any party, complainant or respondent, but the respondent may want to have an attorney serve as their advisor during their interview with the investigator. And as Chris pointed out, the advisor may be present at all stages of an investigation, but may not advocate in the interview. A lot of attorneys are going to have a hard time with that. Attorneys are there to advocate, they're there to participate, to intervene, sometimes even create a little chaos. And so the investigator, if this occurs, the investigator is going to have to kind of remind the advisor, or in this case, the attorney, that the respondent, is the one who's being interviewed, not the advisor, and that they need to, if they want to talk to their client, they can take them out in the hall and talk to them, but they don't need to interfere with the investigative process.
Exactly. All right, so let's look at a quick hypothetical here about advisors. So the school district's investigator is preparing to interview the complainant during a Title IX investigation. The investigator receives an email from the complainant's parent, and she would like her neighbor to serve as her advisor. Title IX coordinator receives an email from the respondent requesting that the school district appoint an attorney to serve as his advisor during the investigation. So two different scenarios there. Let's look at them both. So Ashley, I'll put this one on you. Can the complainant's neighbor serve as an advisor during the interview?
Sure. Anyone can serve as an advisor as long as that advisor is not otherwise involved in the formal grievance process. So if I'm going to change it up a little bit, if the complainant's parent said, I want this assistant principal to be my daughter's advisor, that would be fine as long as the assistant principal is not your investigator, your decision maker, your appellate decision maker, or someone who has already or may facilitate an informal resolution.
And one thing, Ashley, I think that's important there let's get this straight for, K-12 school districts. An advisor could be anybody, and a party's entitled to have an advisor present throughout the investigative and decision-making process. But is the school district required to appoint an advisor for a complainant or respondent?
No, during the investigative process, the district has no obligation to appoint anyone as an advisor. The advisor should be a voluntary role.
Right. So, Dean, I'll ask you sort of, this one kind of plays in between both of the hypotheticals there that Ashley looked at. So, following up from that, the respondent has asked the school district to appoint an attorney to serve as his advisor during the investigation. So, does the school district have an obligation to appoint an attorney at any stage, whether it be the investigation or during the decision-making process?
Absolutely not. So the respondent can choose to have an advisor. As Ashley said, it's voluntary. It's up to the respondent or the complainant to obtain their own advisors at the K-12 level, especially at the investigation stage. Certainly a school district could choose to appoint an advisor for the respondent and the complainant, somebody who can help them through the process. Again, that would not be the Title IX coordinator, who should remain neutral and just coordinate the process. But certainly the school district could do that. That would mean another set of people that the school district will need to potentially train on the process as well. But it might not necessarily be a bad idea to have, especially if it's the allegations are very significant, to have somebody help the student and the parent through the process.
I think that's a really good point right there too, Dean. There's no requirement under Title IX that a school district appoint an advisor, but that is not a prohibition against the school district making the choice to have advisors for complainants and respondents. But I think very important to have a conversation with the school board attorney about, if you're going to go that route, the pros and cons, and also making sure that if the school district's going to appoint advisors, as a matter of policy, that those advisors receive training under Title IX and the school district's policy.
Go.
All right, let's look now at the evidence function that an investigator will use during the investigation. So we've talked a lot about meeting with the complainant, meeting with the respondent, interviewing those parties and talking to any additional witnesses, reviewing documentary evidence. So the totality of all that becomes the record that you're compiling, that you've got to also synthesize and evaluate. So the main function of an investigator is to objectively, not subjectively, taking your own thoughts and preconceived notions about what the facts mean, but objectively evaluating all the physical, documentary, and testimonial evidence which you have put together to determine whether or not all that evidence supports a finding of that a policy violation occurred under Title IX. So let's look a little bit more specifically at some of the ways that an investigator should be evaluating the evidence in the investigation. One of the main functions that an investigator has during the investigation is to determine the overall relevancy of a particular document or a particular piece of evidence. So evidence is generally considered relevant if it has some value in proving or disproving a fact at issue. So taking a look at whether it's relevant, if something is relevant, then it should be considered. So the investigator's job is to look at the evidence and determine relevancy, and in looking at the totality of that evidence and that relevancy, putting it together in the investigative report. Ultimately, it's the decision maker's job to look at the evidence and make the final determination as to whether or not a policy violation occurred. But the investigator serves an important function before that in collecting and analyzing and synthesizing that evidence before it gets to the decision maker's desk. Ashley and Dean, do y'all have other thoughts on determining relevance as an initial stage in the investigation?
So one of the things I would say, Chris, is that don't overlook small pieces of evidence that will help you establish whether or not something happened. And, a lot of times, and this is why you have to, or it's so important, as you mentioned earlier, to go into this objectively. If you have a preconceived notion of what happened or what didn't happen, that will allow you to easily overlook a small piece of evidence that's not smoking gun, right? You're not likely going to find a ton of smoking gun evidence in some of these investigations, but the text message that's sent at 12:30 p.m. might give you, the timestamp on it might give you some corroboration to a fact in your investigation. Maybe the information in the text message itself doesn't, but the timestamp does. And so don't allow little pieces of data to get by you or think that they don't have any significant meaning, because they may. Now, as you pointed out, relevance is up to the decision maker, but the investigator has to put the relevant evidence the evidence that they believe in front of the decision maker too. And then it's up to the other parties to decide whether or not that other information may be relevant that was overlooked by the investigator or the investigator didn't consider to be relevant. And so take all the information in that you can and try to synthesize it objectively and pass that information along to the decision maker. But this is the information that has to support the investigator's findings and conclusions.
Here are a couple of examples of the types of evidence which the investigator should not elicit or rely on. So under Title IX, no person acting on behalf of the school district can rely upon or use questions or evidence that seek disclosures of information protected under legally recognized privileges. So the privileges that we've listed here are ones that you may have heard of before: the attorney-client privilege, the school counselor or student privilege, the healthcare provider-patient privilege, and then a privilege related to the Rape Crisis Center and domestic violence programs. So I think what we're trying to say here is, in conducting the investigation and in interviewing the complainant and the respondent, the investigator has to be careful not to elicit information through questions that would otherwise be protected under one of these other valid privileges, because ultimately that information would not be relevant. Now, Dean and Ashley, how does this square particularly with the school counselor of a student privilege? What if this is a situation where, what if this is a situation where the student came to the counselor and the counselor was the one that actually received the initial Title IX report? How is that going to square with the existence of this privilege now that we're in the investigative stage?
So I think we've said in a previous training that the school counselor student privilege relates to the school counselor cannot be compelled to testify regarding what they've learned in a counseling session with a student in court in a lawsuit or claim or proceeding. And again, under Title IX, the school district cannot compel any employee, including school counselors, to testify in a proceeding, in an interview in the Title IX process. But the privilege itself applies to open court testimony. And in open court testimony, only a judge can compel a school counselor to testify in regards to what they've learned from a student in a counseling session. I would say that one thing Title IX coordinators should definitely consider is if you think you're going to have cases that involve mental health records or medical records from a healthcare provider or any one of these privileges, you should develop a template form that asks for a student's or student's parents' consent to waive these types of privileges. If you develop one of those forms and let's say a student's parent comes in to make a formal complaint on behalf of the student, you can easily give the student's parent at that time a release, basically a waiver of the school counselor student privilege or the healthcare provider patient privilege. And that way, when it comes to the investigation, your investigator doesn't need to worry about what kinds of questions they can or cannot ask because you already have on file a waiver of that privilege.
That's a great point, Ashley. And I just want to hit on that just again, that the privilege belongs to the student, and the student can waive that privilege. So it's the school counselor is not the one who has the privilege, or the doctor isn't the one who has the privilege. They're the one that is bound by the privilege, and they can be released from that by receiving some sort of permission from the patient to patient, or the student who is the patient or the client, to release that information. So always keep that in mind. And schools do this all the time, especially with students who are receiving treatment for mental health, or they are disabled students or students with disabilities. And the IEP team will ask the parents to sign a release to allow the school to talk to the doctor, that sort of thing. So school folks are certainly understand this process pretty well, and know how to work within it, and to get the information that they need. Sometimes the student won't waive the privilege, and that's okay, and we respect that. But always remember, it's up to the student to waive it.
All right, so we've talked about in weighing evidence and trying to make a determination in the investigative report. We've talked about weighing evidence. We talked about relevance. One of the other jobs of an investigator is to assess the validity of the evidence and determine credibility based on the substance of the interviews with the parties. So again, one thing you should avoid doing, and you have to do under Title IX, is you shouldn't make any credibility assessments, sort of like who's telling the truth, who's not telling the truth, simply based on the status of a party. So a complainant or a respondent or a witness is not more inherently believable. It's based on the individual facts of the case and the testimony and the documents that are supporting the interviews that you're conducting with the parties. So the things that you're looking for in determining credibility and the believability and the veracity, the truth of what the parties are saying, what a witness is saying, is how accurate and reliable is their information. Does the person have, a motive to lie? Does their story make inherent sense? Do the facts that they are telling you in the recounting of what they've observed, are they consistent and corroborated by other parties' testimony, or are they directly contradicted? All of these things are going to add up to a determination for you as the investigator as to, in weighing the overall evidence, whose evidence seems to be more credible. So, sort of to add on to that, you should be aware of, inconsistencies in statements among parties during the investigation, and corroborating those statements with other statements of witnesses. But, you shouldn't rely too much on seemingly irrelevant inconsistencies, meaning if a party tells you that they left a classroom, at 12:30, and you later get, a text message, you're looking at text messages related to that statement by a party, and the text message shows that, with a time step, that it was actually, closer to 1. Well, you need to ask yourself, does that difference in time really matter for the facts and the allegations that are at issue? Or is that seemingly something that they just may have been mistaken about, and, and were wrong by, 15 to 20 minutes? Or is that 15, 20 minutes very important to the timeline of what you're investigating? If it's not, you don't want to give too much weight to the credibility of a party if it really has no bearing or no meaning on the facts that are at issue in the allegations of sexual harassment.
Chris, let me throw you a curveball. And we've always seen in cop TV shows that a detective, and they're asked, how do you know that that witness is lying? How do you know that it's this person? And the detective goes, I just have that hunch. It's in my gut. Can an investigator in this process use their gut feeling or that hunch to determine a party or a witness's credibility?
No. So, you should avoid that and base your credibility assessments on the evidence. So your job is to, at the end of the day, collect and marshal the evidence and assess its validity. So, when you're looking at someone's credibility and you're determining their worthiness, for belief, you really should look at the evidence and what it says, is what they're saying backed up by other people's statements? Is it backed up by documentary evidence or physical evidence? And if it is, then that would boost their credibility. But just a sort of hunch kind of goes back to that first bullet. And you have to really avoid not making these sort of gut decisions based on, your own personal experience or your preconceived notions about the Title IX process or the nature of a complainant or respondent, or things you might know about a witness. You really need to base it on the evidence that you've collected and the record for the investigation.
And credibility determinations or thoughts or findings by the investigator are very important in K-12, especially if there is no possibility of a hearing occurring where the decision maker has the ability to hear from live witnesses and determine credibility. Now, that's going to depend on how you change their policy, and we've talked about that in some other of the training sessions. And it will also depend if there's some sort of due process for like a long-term suspension or a employee termination. Those would certainly generate hearings too. But if the decision maker in the Title IX process isn't going to have the benefit of the hearing, they're going to rely heavily on the investigator's thoughts of credibility. And just want to also point out that an investigator can if you've got two parties, a complainant and a respondent, and the complainant provides you with three witnesses who saw the respondent's conduct, and the respondent denies doing that conduct, but you got three witnesses and the complainant who testify that it all happened and they were all eyewitnesses. That's corroborating evidence to the complainant's credibility. That doesn't necessarily mean you have to give some sort of other reason why the respondent story is not credible. You've got your reason in the corroborating eyewitness testimony. So keep that too. You don't have to make some sort of finding specific to every time you believe somebody's not credible, but you do need to determine whether the folks who you do find to be credible, and if there's a real reason why you find a party or witness not to be credible, you do need to list that too.
And always keep in mind that, the investigator's job culminates with the investigative report, which we'll talk more about in later slides in this training. And that investigative report is going to be what the decision maker reviews, in summarizing the evidence, in helping form their basis for the decision. So it's very important that you keep that in mind when you're looking at the evidence and you're writing that report. All right, let's look at just a couple, kind of tease out a few of these ideas here on relevancy of evidence. So Ashley will do this one first, and then Dean will look at the second one. So the investigator interviews one of the witnesses to the alleged incident identified by the respondent. At the end of the interview, the witness reads back through their text messages with the respondent on the evening of the incident. So Ashley, are these text messages relevant? And if so, what should the investigator do at the end of this interview?
I would say that most likely the text messages are relevant. Remember that you're looking to determine if the text messages prove or disprove whether alleged sexual harassment occurred, or prove or disprove the credibility of one of the parties, particularly the complainant or the respondent. And so if a witness is reading through their text messages after being interviewed, the witness certainly thinks that the text messages are relevant, which would be why they're reading them back to the investigator. And so the investigator should definitely make copies right then and there, or ask for copies of the witness of the text messages so that the investigator can go through them later on, and refer to them in a follow-up interview with the respondent and possibly with the complainant as well.
Exactly. And, I think these text messages, when they're printed out, those become the documentary evidence that we're talking about. So, one other sort of wrinkle to that is, if a witness is showing you text messages from an evening, and the evening is the evening of the incident, it may be that, they're showing you 25 or 30 text messages, and only 2 or 3 of them actually relate to the incident or have any bearing on it. So Ashley, what do you do if a witness hands you 10 pages of text messages, and when you look at them, only really 3 or 4 of them have any bearing on it, and the rest of them talk about, what their plans are for the weekend?
If I were the investigator, I would thank them for the text messages and still ask for copies right then and there, because those 3 or 4 you may use. But also keep in mind that if you collect that evidence, you will be giving that evidence to both parties at the end of your investigation, or right before the end of your investigation. So just keep in the back of your mind that the parties will see all of the text messages, the 3 or 4 that may be relevant and the other 20 that are not relevant. But it's not up to the investigator to shield that from the parties, because this is supposed to be a very transparent process.
All right, so Dean, the second one: during an investigation, the complainant shows the investigator copies of social media posts made by the respondent on the evening of the alleged incident that have since been deleted by the respondent. Are those posts relevant? And if so, what should the investigator do?
It's going to depend on what the post said. Certainly, the complainant has provided that information, and so the investigator should review that information and determine whether or not the information is relevant. Could it be possible that the mere deletion of these from the respondent's social media page is relevant in and of itself? Absolutely. That could be relevant too. And so the first thing I think the investigator needs to do is to review it, determine the text, whether the text in the messages is relevant to part of the alleged incident, whether, as Ashley said, does it prove some sort of credibility issue, or does it go to prove or disprove sexual harassment? And then the respondent should, if assuming it is relevant or some part of it's relevant, the respondent should be asked about the social media messages, why they were deleted, and if the respondent actually posted them in the first place, and what the respondent meant when he or she posted that information too. So the investigator should make those determinations, and it very well may be relevant to the investigation.
Exactly. All right, so moving along in the investigative process, we've talked about the upfront obligations of conducting interviews. We talked about weighing evidence, determining credibility. So you've done all that. Now you're sort of ending the end of the process. So then the investigator's job is really to figure out what are the next steps, and weighing the evidence and creating an investigative report. So each case is going to be different, and the facts of each case are going to be different. Some will be more complicated than others. So your job is to take all that evidence and measure it against the policy, and make a determination of whether or not you think there was a violation of the policy, and determine if that was, and recommend to the decision maker whether or not there was a policy violation based on the evidence. So in some cases, especially if it's a Title IX violation, you're going to find that there may have been some, but not all, of the allegations were proven to be supported and true. You may conclude that the respondent did not commit any of the alleged sexual violence or misconduct, the harassment. There was no harassment. And the other option is you may find out that the evidence is just inconclusive. you interviewed the complainant, you interviewed the respondent, you had some witnesses you talked to, you collected a lot of evidence, but at the end of the day, there wasn't anything that looks conclusive to show beyond with a preponderance of evidence that the policy was violated. So you just can't figure out who's being truthful. The complainant and the respondent simply have different stories, and the respondent denies that the sexual harassment actually occurred, and you're having trouble finding corroborating evidence that it did. So you're having trouble making a conclusion. So those are just kind of the typical options that you're gonna look at while you're working to put the investigative report together. In the instance that you feel like the evidence is inconclusive, that may ultimately prevent a remedy by the school, but it should not prevent the district from supporting the complainant throughout this process.
Chris, remember that the burden of proof is on the school district. The burden of proof is not on the respondent or the complainant. So it's up to the investigator to determine whether or not the sexual harassment occurred by a preponderance of the evidence, unless you use the higher clear and convincing standard of evidence. And when you are in a situation where you have basically, for lack of a better word, he said, she said, allegation and denial, then it may be very difficult, especially if you cannot determine which party is more credible or less credible. It may be impossible to determine by preponderance of the evidence that anything happened or didn't happen. And so again, option 3, I have seen option 3 occur a lot in a Title IX investigation, even prior to the new rules, where the district basically had to determine that the evidence is inconclusive. We cannot figure out exactly what happened or who's being truthful. However, these are the supporting measures or measures that we are going to put in place in order to ensure that this doesn't happen again, or to support the complainant. So always keep that in mind. Now, option 3 is a viable option if it is really difficult to determine by preponderance of the evidence of what happened.
So we'll take a look at the very end of this process. So before you complete the investigative report, the investigator has got to send. So before you actually complete your investigative report, you may have weighed all the evidence. You've got to compile all that evidence and you have to send it to both parties, and they have a right to take a look at that evidence before you finalize your investigative report. So that's very important. The parties have a number of days to submit a written response before the investigator finalizes the investigative report, and the parties' responses should be considered by the investigator before they finalize the investigative report. So again, this just goes back to the equitable prong. We talked about the key hallmarks of an investigation under Title IX being prompt, thorough, and equitable. This is promoting the equitableness by making sure that essentially all the evidence that you've collected is shown to both parties, and they have an opportunity to look at it, review it, and respond to it if they believe that there are questions or any of their statements were mischaracterized or misconstrued or taken out of context. Gives them a chance to clarify those before the decision-making process starts. So what needs to go in your investigative report? So again, the biggest thing is that the investigative report is going to take all the evidence and fairly summarize it. As you can imagine, with allegations of sexual harassment, there are, a lot of evidence may have been collected depending on the size and the scope of the allegation. So your job is to weigh all that evidence and summarize it, synthesize it in the report. And again, the investigative report is going to be one of, these 5 or 10 different form letter type documents that you need to work to create, because it will be, having a template to start from, of course, the facts The outcome will be different in each case, but having a template to start from will make this a little bit easier to put together. But Title IX requires that the investigative report has summary of the allegations and the responses, a summary of the investigative steps taken. So when did you start the investigation? Who did you talk to? Who, what, when, where, and how long did that process take? Of course, a summary of the evidence that was relevant to the determination, and then ultimately a recommendation on the question of responsibility and any recommended disciplinary sanctions. So those are the things that need to be in an investigative report. Those are the tools that a decision maker would want to have at their disposal when they are reviewing and trying to make a determination based on responsibility in the final part of the Title IX grievance process. The investigator should provide a copy of the report to all parties, again, equitableness, and the parties have a number of days to submit a written response after the investigative report, in addition to any written questions from other parties or witnesses. So again, the investigative report is the very end of this process, and it really just kind of puts together all of the information and the collective steps that the investigator's taken to lead it into the final phase, which is the decision-making phase.
Chris, just a note on the timeline of this process. If you're noticing that the length of how long this process takes is adding up, it's a long time. Remember that the School Board Association model policy says that the district will complete an investigation within 90 school business days. And before the investigative report is sent out to the parties, they get all the evidence that the district has collected and have 10 days to submit a written response to the evidence. Then the investigator considers that before submitting the investigative report, and then the parties have another 10 days to submit a written response to the report itself. So that's 20 days right there. So I just recommend when you do get a formal complaint and you send out the written notice of allegations, do not delay in scheduling interviews and trying to get evidence. Do it as quickly as possible, because you do have these Title IX required time periods that you have to factor in at the end of the process.
And Ashley, this is another good opportunity to reiterate something we mentioned earlier in this section, and that is that the informal resolution process is so important. It's so important to have a good mediator or facilitator to try to get these things settled. And one of the reasons why is because of the time it takes to go through this process. Now, we certainly should not browbeat anybody into trying to settle or to reach some sort of mediated agreement through informal resolution. But we really should attempt to, especially smaller disputes, try to resolve them to the extent that we can through informal resolution. Can you imagine going through this entire process and giving it, at this point in time, 90 days, 90 business days is a semester, pretty much, if you have a 180-day school calendar. And so you could start, something could happen on the very first day of school, and it's taking until Christmas to get everything wrapped up. So, and we usually like to operate a little quicker than that, but when you start throwing in everybody else has 10 days to write a rebuttal or 10 days to provide this, it automatically, stretches the process out.
Kind of wrapping this up again in the investigation, just some tips to avoid common reporting writing efforts. You can imagine a couple of these. Make sure a lot of this goes to the thoroughness. We talked about prompt, thorough, and equitable. A lot of this goes to thoroughness and the equitable prongs. So make sure that you're doing a complete policy analysis. Make sure that you are looking at each prong in the Title IX policy and making sure that there is evidence to support the allegation that covers each part of the policy. That's important to make sure you're doing a complete and thorough policy analysis. Soft report writing, again, your job is not to minimize the facts. Your job is to collect the facts through the evidence obtained through the parties and witnesses, and write a report that reflects the actual evidence that you're being collected. So, don't lean towards leaving something out because you think it may hurt one party or another. That's not your role. Your role is to collect the evidence and present it in an objective fashion so the decision maker can have all the evidence in front of it when they make their decision. We talked a lot about credibility, what it is, how to make a credibility assessment. When you spend time thinking about that and you include that in your report, don't leave it out of your report. Your assessment of the evidence and how individual facts build on each other, corroboration, and your ultimate credibility assessment of the parties are very important pieces to whether or not the Title IX policy was violated. So, don't leave that out of your Title IX report. And finally, this is not necessarily for just the report, but in general, your job, again, is to collect the evidence. It's not to argue for or against the evidence in the report. So don't serve as a cross-examiner. Your job is to objectively look at the evidence, collect the evidence, and then pass it on to the decision maker for their ultimate decision-making process. And again, just leading it right into that, once the investigative report is complete and the timelines have passed and there haven't been any responses, the investigator will then provide the decision maker with a copy of the investigation report, all the evidence, the party's written responses to the report, if any, and also a description of the procedural steps taken, starting with the receipt of the formal complaint and going all the way through the very end of it. So you can essentially, think of this as the record of the case. This is everything that's from start to finish in your investigation, kind of culminating with your investigative report, which should lead you through the evidence that was collected. All that needs to be turned over to the decision maker before that part of the process commences.
Chris, should the title of this slide be hands off? Sorry, had to end on a joke. Thank you. That's the end. Yep, that's the end. Anything else to add, Chris or Ashley?
Nope.
Sorry again, had to end on a joke. We don't get too many opportunities for a joke in a Title IX training. So thank you for joining us on this one. We will be back with Section 7 on the hearings, which will be optional, but we'll certainly explain that when we get there. And then we'll finish up with Section 8, determination and appeals. Thank you all again, and thank you, Chris and Ashley.